Welcome. This is time, sir. It's your boy Phil coming at you. I got all little clips from today. I just want to take a second to thank everybody. The response has been huge. I know I'm a little guy in the game right now, but my subscribers are growing by the day. I'm so glad all the comments are coming in. I'm getting letters. It's just a great feeling, guys. Help me quit my day job, please. This first one up is very bizarre. It's a jail court. I don't know where it is exactly. First of all, the judge looks like he works for the CIA. Second of all, the prisoners are just whoa. So this first one is hysterical. Just watch his behavior. It's very bizarre. So let's get into it.
7-3-8, State of Texas versus Tyler Daugherty.
He's right here, Judge. That on the blue decal. Okay, stop talking to yourself.
Sir, please
Talk to the judge.
Sir, please raise your hand and be sworn. You swear to tell the
Okay, first off, the security guard goes, stop talking to yourself and talk to the judge.
truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Sir, you're charged in both cases with the offense of criminal trespass, Class B misdemeanors, punished by fines of $0 to $2,000, $0 to 180 days in the Bexar County Jail. You understand what you're charged with and the range of punishment in each case?
Yes, sir.
I can't.
You can put your hands down, Mr. Daugherty.
Sir, you understand what you're charged with and the range of punishment?
Yes, sir. I think so.
Stay there. Is there an agreement?
In cause number 700738, $0 fine, court costs 17 days of confinement, credit for time served, time and money during concurrent. State will take into consideration and dismiss cause number 700054. Intend the judgment be satisfied.
Is that the agreement?
Yes, Your Honor.
Sir, to that offense, how do you play? Guilty, not guilty, no contest.
He's thinking about it.
It's no contest, Mr. Daugherty.
Sir, you're going to have to take your mask down and speak loudly. How do you plead? We can't hear you.
Guilty.
It's no contest, Mr. Daugherty. That's what, but it's the same as a guilty plea, but the
Oh,
paper
wow.
says no contest.
No contest, sir. I believe no contest.
You understand on a no contest plea, I can still find you guilty?
You have to say yes. It's the same as a guilty plea. No contest, same as a guilty plea. We went over this.
Mr. O'Donnell?
Yes, I say yes.
Yes, yeah.
Anybody force you, threaten you, or coerce you to make that plea? Sir, you got to speak loudly.
I think yes, sir. I think so. Therefore.
Sir, anybody force you, threaten you, or
No.
coerce you to
No,
make
sir.
that plea?
He's
Making
literally
it freely and
he's
voluntarily.
He's a
No,
real
sir.
live buffer.
Sir, please listen to the questions. You may making your pleas freely and voluntarily.
What did you say, officer?
Mr. O'Donnell, I'm beginning to think he might need to visit with Judge Carruthers.
I understand, Judge, when we had our talk, my client wasn't like this. He said he wanted to accept the offer. No one's forcing him to do this.
Sir, we're going to try again. Anyone force you, threaten you, or coerce you to make that plea?
It's loud, sir. Loud.
Loud.
It loud. No. No, sir. I didn't.
Making it freely and voluntarily.
It sounds like someone's twisting his leg.
Yes.
Anyone
Yes,
offer
yes,
you
yes.
anything other than a plea bargain to get you to make that
You
plea?
win it, yes. Someone wins. Who wins? Who wins? Someone wins.
All
Yes.
right, Judge. I think
Someone
that's
wins,
enough.
yes.
Sit down.
Who wins?
Sit down.
All right.
I
He didn't
can't.
start behaving this way until he kept in front of the computer.
Oh, well, bring him back in front of the computer for a minute.
All right, not for nothing, but you're the judge. Fix your Zoom. Fix your Zoom.
Mr. Daugherty,
Okay, I
here's the deal. If you don't understand what I'm saying, I'm going to have to send you for a psychological examination, and you'll be sitting in jail probably another 30 to 60 days until that's completed before we bring your case back.
Oh, sure.
Now, if you want to continue to act like the way you were acting, I'm going to have to send you for that psychological examination. The deputies are telling me you weren't acting that way when you were talking to your lawyer. So now, if you would like to answer my questions straightly, I'll take your plea and you can conclude your case today and be released. And if you
Yes,
want
sir.
to continue to act up, I'll send you to Judge Carruthers and you'll sit in jail until your psychological examination is complete. Which do you want to do?
Dun, 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 dun.
What do you want to do?
Yes, sir. Yeah. Sir, it seems like something just will not let me think correctly. I want to,
Hold your brain.
Sir, if you're having a mental thinking problem when you're at the bench, I'm going to have to suggest that you examined. So if you want to get out today, you're going to have to get coherent immediately. If you don't want to get coherent immediately, I'm going to send you to Judge Carruthers for an examination.
For you.
So I'm going to try the question again. You making your plea freely and voluntarily?
Say it louder.
Got to speak loud, sir.
Just put the headphones on him, Judge.
Now he's gonna get the headphones on. I love it. I love it.
Put these on.
Sir, you're making your plea freely and voluntarily.
Hang on, Judge.
please, sir. My plea is that.
Hang on. All right, now.
Yes, sir. Yeah,
Sir, you're making your plea freely and voluntarily.
I wish, I could stay, please. I wish I could stay. That I'm asking, please, for longevity. One day wins me.
Mr. O'Donnell,
I'm sorry, Your Honor, my client wasn't like this when I talked to him. I don't know exactly what's going on. If I could try again in the breakout room, maybe I can talk to him where he'll understand, but he wasn't like this before, Judge.
well,
Nut.
I'm going to send him back to the breakout room, and if you can't straighten him out to come back to the bench to
That
take the
headphone
plea,
on.
I'm just going to send him to Judge
You
Carruthers,
think
and
he
he can
works
just
for
sit
customer
in jail.
service for
Thank you,
Amazon?
Your Honor.
Sure.
Customer service for Amazon. How can I help you?
Sir, you need to go back to your computer in the breakout room.
Okay, yes, sir.
You need to take that headset off and go
Poor
back.
guy.
Done?
Oh man, if you don't love court shows, I don't know. This is the greatest thing. Oh God, I just can't. All right, guys, let's go to I haven't had a clip of her yet. It's Judge Washington out of Michigan. She's fantastic. It's quick. It's quick. Somebody just kind of disrespects her, and she doesn't like it. It's real quick. I just love her attitude. She's no nonsense. She's just straight. She's just even keeled all the time, whether she's happy, whether she's sad. She just sits on that bench, and she's just stone cold.
Down months in prison.
Thank you. It's on now, sir. So you need to take off your hoodie.
Ew.
I'm sorry, what did you say?
I'm sorry.
Nope. Damn.
Down months in prison.
Thank you. All right, we're here today on a what looks like a pretrial. Mr. Munson was arraigned on his failure to appear for court on January 12th. He was arraigned on
We're
that
just
failure
going to
to
hear a
appear
little bit
bench
about his
warrant on
case, and
January
I guess she
26th.
ripped into him a little
So
bit
we're
at the
here for a
end.
pretrial
But I just
today.
want to address
That is
What is
correct,
going
Judge.
on with Mr. Lorenzo Sadler?
People will be
Is
asking
he a
for an adjournment. I think this is one
astronaut
of the
caveman of
THC
some
case.
sort? This is what attracted me to her courtroom today, because I'm looking and I'm going, this guy's going to be great, and it ended up being nothing. It was just, it was 1, 2, 3. But what is she got going on there? He's Event Horizon in the background with a blanket and his Snuggie. I mean, way to just show up to court. I mean, come on. And I mean, if you're talking about Judge Bryant, could you imagine if he was in Judge Bryant's court? Oh my God. I don't even think Simpson would let him get away with that. Well, Washington, she don't care because she's pissed off at this other guy, but come on. I'm just going to jump a little bit here to where she rips him.
Requested, but I haven't received the.
Thank you. 2023, and that is going to be at 9 a.m.
Captain
Mr.
Caveman.
Munson,
Here we go.
Yes.
the time before when you came into court, you were driving while you were on Zoom. This time you're cursing while on the record. That's your second strike.
I apologize for that, Your Honor. I kind of, yeah. Cursing is kind of like a.
Like what?
I apologize for that, though. Kind of slipped out. That was very inappropriate of me.
All right. At least he
We'll
apologized.
see you back here on March 16th. Bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Okay. Are we ready for this one? I don't think you're ready for this one. So, this next one is a little mental disorder going on. Okay. But his arrest and then the charges and the events that led up to where he is now and what is hanging on his head right now, just pay attention to ASG Jones and the words that are coming out of his mouth.
Let me ask Ms. Moore, do y'all need a little more time to get some evidence together on these other offenses?
When I spoke with Mr. Jones yesterday, he said that he was going to reach back out to me and speak with Ms. Brower.
All right, Mr. Jones, any development on that?
Your Honor, so at this point, there has been no development as you're aware. We were in court all day yesterday, and I spent the latter part of the afternoon preparing for today's calendar. So at this point, we can't go forward with the hearing because there isn't the officer available to actually testify as to what the subsequent offenses were, and that would be the reasoning for the revocation of probation. So I don't think that we're going to be able to revoke his bond today, Your Honor. However, if I may proceed with the case that is actually holding him in custody, the state would like to argue.
Go ahead.
I'm sorry.
Go ahead.
The state would like to argue that the $200 cash bond, he received $100 per charge, is more than sufficient as it relates to this incident, Your Honor. He is currently, at least on this calendar, there are 3 charges against him. Item 3 is what's holding him in, and it occurred on the 26th of January of this year, is where the defendant did enter a Dollar Tree located at 2104 Henderson Mill Road. He damaged the miscellaneous shelf items. He ended up knocking over the cash register onto the floor, and ultimately he assaulted or battered the clerk by punching him in the face.
All right.
He has currently been in custody for 8 days, and he does have a $100 cash bond again on both charges, which is the criminal trespass and the simple battery. The state's concern, Your Honor, is that item 4 is it relates to an incident location that occurred at 3339 Wembley Walk. The owners returned to the location to receive some items from their home. They did not give the defendant permission to be in their home. Upon approaching the front door, they heard someone inside talking, so they called law enforcement. Law enforcement responded and entered the home after being provided the key by the rightful owners, and they saw the defendant inside the home in the bathroom talking to himself.
Okay.
While being searched, the defendant stated that he was going to defecate on the officers and began to reach in his back pants. Ultimately, he did not, but while he was in the back of the patrol car, the defendant did urinate on himself and did defecate on himself, and then smeared the feces on the rear prisoner screen. This is concerned about his mental health, Your Honor. And also, As it relates to that incident, there was drug-related paraphernalia found on him. So the state is also concerned for drug and alcohol abuse. So we ask that one, you maintain bond where it is, if not increase it. But ultimately, if you were to be able to make bond, Your Honor, we will ask that you impose for him not to return to either of those locations or to have any contact with any of the victims in those cases. And more importantly, we will ask that you impose a mental health eval and a drug and alcohol eval in order for him to complete any substance abuse treatment recommended.
We be pooping in the police car.
Again, be serious with like how you describe that situation. At the beginning,
Sir, Mr. Fisher, I'm going to advise that you don't talk about the facts right now. Judge, I mean, our concern largely is the probation violation because he's currently being held with no bond on that. So I would like to circle back and figure out if.
Well, I mean, at this point, there's no violation. So I'm pretty much not going to do anything on that one, but I am concerned about.
Well, and so Judge, I do understand there's at this point, there's no violation, but there is a no bond probation warrant holding him in custody. So I would ask that if we're not going to proceed on that at the time, that warrant be withdrawn.
What does probation want to do on that?
I want no part of him
to withdraw the warrant. He has had over 5 criminal trespassing charges in the last 6 months.
All right, when will you be ready to proceed on this case with testimony from officers?
Probably next week.
All right, we'll bring him back next week.
Okay.
All right. In the meantime, I'm going to leave the bond where it is on the simple battery criminal trespass position 3, $200 bond.
Yes,
Deputy, we are
you
done
said
with
next
Mr.
week.
Fisher.
You said next week for a full hearing.
Yes, on the probation revocation.
Okay, and Judge, and will that be scheduled at traffic court in person then?
Oh, no. It'll be by Zoom, I guess.
So it is a testimonial hearing, Judge. So I believe our position is that those have to be.
Consented to. Well, is that something you're willing to consent to, Attorney Bauer?
To do it over Zoom? I'll have to double check with our office. I believe our position is that testimony.
I really wouldn't. I don't know if even if she agreed that would be sufficient. Miss Mitchell, when is our next potential in-person hearing date?
February 27th.
That's arraignments though.
Calendar call.
That's calendar call.
It's calendar call.
All right, they're just arguing over what day and time they want to have the poopy back. All right, let's go. Now I got some quick little Simpson clips, nothing crazy. Just cute little moment with 2 attorneys. Someone that keeps repeating behavior in Judge Simpson's court, striking motions, doing everything crazy, and Simpson had it with him, so he loses it on him. And then just another cute one with a guy just in jail that is, you'll see.
Deon Leonard, the prosecutor on it.
Ashley Lundy standing in for Nimish Ganatra.
Oh, I'm here. Nimish Ganatra, First Assistant Prosecuting Attorney for the people. And Mr. Vincent.
Good afternoon.
Okay, so I'll set it up for you. Prosecutor Ganatra and Attorney Michael Vincent. He's a private attorney. He's not a public defender. He's a lot of the guys in the local area, Waukesha County. He's in Judge Simpson's court a lot. And they kind of bust his chops all the time. So there's a real light moment here between the lawyers and Simpson that was just really cute. I think you guys would really appreciate it.
He's here.
Mr. Ganatra, Michael Vincent on behalf of Deon Leonard, who's present in my office.
All right. State your name, sir.
Deon Leonard.
Thank
Big
you.
bad Deon.
All right. What are we doing today?
Just need a prelim date, Your Honor.
In person?
Zoom if we are still doing that.
Well, I guess you got about another 26 days. If you want it by Zoom, I can get you in.
All right.
You want it by Zoom?
Sure. Yes, Your Honor.
Okay. How soon you want to do it? I can do it February 21st. Will that work for you?
Tell the judge.
Yes, Your Honor. Thank you.
Oh, yeah, all right. February 21st. You're welcome. February 21st,
Wait a minute, I got-
2023, 9 a.m. That's via Zoom. That is before Judge Balvo.
And I just want to compliment Mr. Vincent
Here
on
we
that
go.
very sharp jacket he's wearing today.
I need all the help I can get, Mr. Sinatra.
It's a good look on you,
Oh,
Mr.
that's-
Vincent.
That's
Yes.
propping him up. Okay. Yes, it does look good on you, Mike.
A Christmas gift from my wife.
Oh, yes. Okay, so that's why we knew you didn't pick it out.
Yeah, absolutely.
It looks so good.
Your Honor, just confirming, February 21st, 9 a.m. via Zoom, and that's before which judge?
Judge Balvo.
Oh,
Thank you.
And not for nothing, but you know how they have the virtual backgrounds? You know, I have my regular one, but you know that virtual background? Those are real encyclopedias. This guy has the Encyclopedia Britannica probably from the 1910s up there. Like, what's going on? It's fantastic. Those are real. His virtual background is real. Next up.
Thank you.
All right. Court calls the case, People versus Romeo Smith. Few cases. Those are arraignments.
Nimish
they
Ganatra,
are.
First Assistant Prosecuting Attorney for the People.
All right, Mr. Smith, can you state your name?
Muhammad Martez Smith.
Here we go.
All right. Okay, Mr. Smith, you're here for arraignment on two cases. First case being 23 F5 5512, and also the case of 23 F5 5001. And where are the complaints in these?
And Samsung up at the
Okay.
top. Doesn't stop moving. It's so annoying.
All right. So in the first case I mentioned, sir, you're before the court on the charge of breaking and entering a motor vehicle to steal property, $200 or more, but less than 1,000. Okay, and that's alleged to have occurred November 18, 2022. Do you understand what you're charged with?
Yes, sir.
All right. There's also a second or subsequent offense notice, which makes this a felony punishable by up to 5 years incarceration and a $10,000 fine plus court costs. The fine can be increased if the value of the property, which is stolen, if that's greater than $10,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. That's on one case. And then on 5001, you're before the court on a complaint that also alleges the offense of breaking and entering a motor vehicle to steal property. And that's alleged to have occurred January 7th, 2023. You understand that charge, sir?
January 7th. I've been in jail since November 18, 2022. So how could that occur January 7th, 2023?
Hold on, Mr. Smith. Hold on. I'm not asking you whether or not you did it. I'm just reading from the complaint. So I'm just letting you know, you understand that's what you're charged with.
Contribute.
I've been in jail since November 18, 2022.
Okay.
Say that happened January.
Mr. Smith,
Yes,
I
I
hear you.
understand. Yes, I understand.
You understand the charge, right?
Yes, sir.
Okay, because I'm not going through any defenses that you might have.
Really?
Is there anybody in court today on any of these cases? Any plaintiffs on any in court today on any of these cases?
What?
Are there any witnesses?
What? Hold on.
What?
Are there any witnesses, any cops, any plaintiffs, any complainants in court?
Mr. Smith, I'm not at that stage yet. I'm just trying to arraign you on the charges to let you know what you're charged with.
Okay.
Okay? So you know what you're charged with. This one here also has the same penalties of up to 5 years, 10,000, or 3 times the amount. You understand that?
Yeah, you know, I'm pretty sure I have enough money to pay the fines today. I can pay the fines.
Okay, but no, well, no.
Shut up.
We're not going to go that route because these are 2 felony cases. One of them, you're telling me that you might have a defense to. So I'm not taking any pleas of any type right now. Now, here's the next question I have for you, Mr. Smith. Do you wish to be represented by an attorney?
Yes.
Thank you. These are public defender cases, please.
May I go state, may I go pro bono and state legal aid? May I go through legal aid and state pro bono? May I go through legal aid, have a state official represent me and go pro bono? That is a right I may have through legal aid. I would like to go state.
Here's what I'm gonna do. This is the way it works, Mr.
Torch.
Smith.
Get torch, yo.
These are PD cases at this point. Okay, and then we'll deal with whatever you're requesting at this point once you deal with them. Mr. Feaster.
Thank you, Judge. We stand mute.
I don't know what the that was.
Feaster had to say.
And in every way, form, or reading, standing mute. Court will enter not guilty plea on both of these cases. I will set probable cause hearing for February 16th, 2023, 9 a.m. on both of these cases.
I got the bass on my back, on my game chair.
And Mr. Smith, I almost hate to ask, what are you in on now?
Just say, just this, and maybe submit a couple of tickets, nothing's holding me. You know, I don't have any O's, you know, I have charged, maybe some misdemeanor tickets through the PD or through the district court. Or 15 districts, misdemeanor, no, I have no hold.
Okay. Okay, so here's what I'm gonna do. On each of these cases, then I'll let the public defender try to address it once they can see what's holding you in, okay? So I'm gonna set a $5,000 10% bond on each case so that you're getting credit for the time you're in against these cases, all right?
Okay.
I will indicate standard conditions, no assault or behavior, no alcohol, recreational marijuana, or any illegal drugs.
You know, I'm having a hard time like getting phone calls out here. You know, I never get a phone call out to make bail. So you know, my mom, I don't know if my mom is still alive. I've been here so long. I don't know. I've been here so long. I don't know if my mom's still alive. I have B&B Payee Services as my representative.
Okay, hold on, Mr. Smith.
He doesn't know what the word pause means.
That's why I gave you an attorney. So when they come and talk to you, you need to tell them all of this, okay? Because you can tell me I can't do anything about that right now.
Okay. You know,
okay, so that's why you have your attorney, so you can talk to them about it.
Okay.
All right, we'll see you in a couple weeks.
Date is set for?
Pardon?
Next court date is set for?
February 16th.
No, the next court date is February 16th, so we're about 14 days out. But that'll give time for your attorneys to get the discovery so they know what we're talking about, be able to see you, hear everything you've got to say, and then we'll try to deal with your case.
Sir,
okay?
may I have a lineup? I would like to set up a lineup.
Okay, hold on, Mr. Smith. Mr. Smith, talk to your attorney about that. I can't.
All right,
do that.
bye. All right, see you later. All right, bye. See you later.
All right.
Okay.
All right. Thank you, Mr. Smith.
All right, thank you. Bye.
Yeah.
Look at him laughing. He loves it.
Finish.
All right, we're going to go to our last video now. And this one is with Mr. Phillips. Now, Mr. Phillips, the story with Mr. Phillips is he keeps putting motions in emails to Judge. And if you follow Judge Simpson or the other shows, maybe Law Talk or Biggin, maybe they put this on one of their shows before. Mr. Phillips has been in front of Simpson several times, and he just gets on Simpson's last nerve. And today he appeared, and when I saw the name, I said, oh, this is going to be good. And boy, it delivered. I mean, not crazy, but boy, it delivered. It was good. So let's get into it. Sorry, guys. Rookie mistake again. That's not going to fly anymore, huh? After I keep making videos, it's a rookie mistake.
More confidence in that. Court does call the case, People versus Justin Phillips.
Here we go.
Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Stuart Collis on behalf of Mr. Phillips.
Hello, Justin Phillips.
Okay, what are we doing on this? Let me just say that.
Here we go. Right off the
Mr.
bat.
Phillips, I told you at the last hearing to not email my chambers directly with these documents that you are doing. You remember me telling you that?
Yes, I do, Your Honor.
Then why'd you do it?
Your Honor, I thought today was a court hearing for 3 p.m. until I checked and it was for 9 and then couldn't log in. So
Why did you email? I'm not talking about the time that you're here.
Oh, I sent a motion in. And the other one was a brief in support
I
of.
told for not to email my chambers directly.
He goes right to his chambers. He emails
You
him
sent
directly.
one at 2 a.m. and then you sent another one at 8:30.
He's got his pair on him, man. You don't care.
Didn't I make it clear the last time that wasn't to happen?
Yes, Your Honor.
Then why'd you do it?
I thought this is how you filed a motion.
You know.
No, you were explained how to file a motion with the court because goodness knows we have repetitive motions before. And I told you not to send them directly to my chambers.
Awkward pause.
Serenity now! Serenity now!
There's a couple of problems with them. One, the one that I was reading this morning that came in at 2 a.m.
2 a.m.
That I was reading is repetitive of the previous motion. And quite frankly, in a lot of respects, it's just plain nonsensical as to what's going on. The one that then follows up at 8:30, although I haven't had a chance to review it in detail because I've been a little bit busy since then, is the same thing. I don't even know why these things are even attached to it.
He's reading the emails. I love it. He gets on his last nerve.
I am very concerned about your inability to follow the court's direction. I'm more concerned in terms of the posture and the way these cases are proceeding. Your inability, it seems to me, and I'm not placing fault on either side, but to be able to talk with your attorneys, because now I'm on attorney 3, and to be able to move this case along. And either one of two things in my mind is happening, but when either there is some type of, and again, I'm not making the accusation, I'm just saying it's difficult for me not to come to the conclusion that there's some deliberate obstruction in terms of the process where you refuse to follow it, or there is a circumstance when I look through these motions and the things that are being said by you in these emails that I can understand your attorney's difficulties in terms of dealing with this case. And I have some very serious concerns from a judicial perspective as to whether or not you can rationally assist in your defense, regardless of who the attorney is. So for those reasons, for particularly that reason, so that when this case decides to move on, the court on its own motion, and counsel, I'll let you speak to it when you want to. I'm going to refer to defendant for competency. and I'm going to set a competency hearing on this defendant. I am just very perplexed by what is contained in these motions. And as I've said, they're illogical. And I think that they're not only just illogical, there are numerous points that they just don't make sense. And not from a legal standpoint, but just in terms of what's being said. Ms. Kirby, any response to the court's referring to defendant for comment? So I'm not requiring a response. I don't think I need one, but I will give counsel an opportunity to address the court.
No response, Your Honor.
Mr. Collis.
Your Honor, I have reason to believe that Mr. Phillips is competent. That being said, I understand the court's concerns. I've had very similar experiences with Mr. Phillips and now received a grievance. I would ask, and I've tried to reach out to Mr. Phillips to bridge whatever gaps he perceived. That isn't happening. He continues to be, as you said, trying to, in my perception, trying to do things that just simply can't be done procedurally and ask me to do things that can't be done procedurally. And for those reasons.
And not just to you, but when I look at these motions or these, I'll call them motions, he's asking for things to be done that factually can't be done. But go ahead, Mr. I didn't mean to interrupt.
No, that's okay, Your Honor. And quite frankly, I believe that there is something at work with regard to Mr. Phillips, but I think with regard to competency, unfortunately, I believe he is competent. And I would just ask the court to relieve me of my duties at this point.
I can't.
I love lawyer talk.
I understand, Mr. Collins. I'm going to at this point, and I understand the position that you're in. I'm going to at this time, I'm not saying that I won't. At this time, I'm not going to do so.
Okay.
But yeah, I'm not going to do that. And it is with great reluctance that I'm saying that to you, but I'm not going to do that at this juncture. The court, then I will set having heard the argument on it, I'll set a competency hearing then for March 30th, 2023, 9 a.m. The court will be preparing the order, sending it out. Counsel will get a copy of the court's order. Mr. Collis, also, if you could make sure, because I don't communicate with defendants directly, that order is then sent over to Mr. Phillips.
So he thinks he's got a direct line to Simpson. That's when Simpson's like, I don't deal with defendants directly.
And Mr. Phillips, I'm just ordering that you'll see the order. You'll get an interview with a forensic psychologist. You are to comply with that.
Yes, Your Honor.
Bond.
I will.
Pardon?
Am I able to speak?
Ooh, saucy.
I don't know what you want to tell me.
Oh, I was going to say that I am competent. I already had a psychological evaluation where I walked in and had one. That was August 29th of last year.
You can explain that to the forensic psychologist.
Okay. And I'm not insane or crazy or anything like that. I'm not sure why the referral, but I understand if that's the court's wishes.
I stated on the record why the referral. You should maybe take some time and read the documents that you're sending to us in a manner that you
Ramblings of a madman. It's Justin Phillips' manifesto.
Thank you. Bond, continue.
Thank you, Ryan.
Well, there you have it, guys. This is my 10th video, and I'm just getting subscribers by the day. I'm getting comments. I'm so appreciative. I'm just going to keep pounding out quality content for you guys. Just remember to like and subscribe all the videos. Just remember, you've been served with your boy Phil, and I'm out.